Alright, this is going to be one of those vlogs where you're going to have to set aside how you may feel about Jussie Smollett personally and actually focus on understanding and responding to the arguments being raised by his attorneys. No one is going to accuse his attorneys of lacking creativity. Viva Frei, Montreal litigator turned YouTuber, and this is the Vlog Dog. Hello Vlog Dog, how you doing? I see. The Jussie Smollett saga is the vlog that just keeps on vlogging. For those of you who don't know who Jussie Smollett is, it's not possible that there is someone out there who doesn't know who Jussie Smollett is. The most recent developments in the Jussie Smollett legal saga, we all know that the city of Chicago was suing Jussie Smollett civilly to recover the overtime expenses and other costs incurred as a result of Jussie Smollett's false claims of having been the victim of a racist and homophobic hate crime. The city of Chicago, under the Cost Recovery Ordinance and the False Statement Ordinance, is seeking to recover upwards of $130,000 in police department resources, overtime costs, for the 2-week investigation into the Jussie Smollett allegations before they determined that no such homophobic hate crime existed and that it was in fact fabricated by Jussie Smollett and staged against himself by himself. Alright, I said I wasn't going to give a rundown and I just gave a rundown. That's what's going on. In early August, Jussie Smollett's attorneys filed a motion to dismiss, and the city of Chicago filed a response to the motion to dismiss, and they are fascinating to read, so let's just get right to the vlog. Defendant's memorandum in support of his motion to dismiss plaintiff's complaint under Federal Rules of Civil Procedure 12.6b. By its complaint, the city alleges 2 causes of action. In count 1, the city of Chicago alleges the defendant made false statements of material fact to Chicago Police Department officers in violation of the Municipal Code of Chicago False Statement Ordinance. Just remember these acronyms: CPD, MCC, FSO, CRO. CPD, Chicago Police Department. MCC, the Municipal Code of Chicago. CRO, the Cost Recovery Ordinance, and the FSO, the False Statement Ordinance. The city claims that because of defendant's false statements, the city expended significant resources and manpower, including but not limited to $130,000 in CPD overtime pay that the city paid solely due to defendant's false statements. Count 2 piggybacks on count 1, alleging that under the MCC Cost Recovery Ordinance, the city is entitled to recover costs of necessary services the city provided in investigating and responding to defendant's allegedly false statements in violation of the MCC. Allegedly false statements. Bear in mind that these are Jussie Smollett's attorneys drafting this proceeding, so they have to qualify the false statements made by Jussie Smollett with allegedly false statements without making a judicial admission as to the actual falseness of the statements made by Jussie Smollett. Count how many times the words allegedly false statement appear in this lawsuit. Now, we have talked about the motion to dismiss Rule 12b-6 in previous vlogs, in the Nicholas Sandman vlog, where I was wrong on my prediction thus far as to whether or not the Washington Post motion to dismiss was going to be granted. The Rule 12.6b motion to dismiss for failure to state a claim means what exactly? Legal standard for motion to dismiss. To survive a Rule 12.6b motion, the complaint must allege, quote, enough facts to state a claim for relief that is plausible on its face. The Rule 12.6b is a motion to dismiss for failure to state a claim. It means that there's a bunch of allegations, but none that state a claim in law that is susceptible to being granted, hence it can be dismissed on a motion to dismiss under Rule 12.6b. And as we get into the pleadings, we're going to see the Jussie Smollett's attorneys attempt to describe the city of Chicago's argument. And you know sure as sugar that when one lawyer tries to describe the argument being raised by the other lawyer, they're not necessarily going to do it in the most objective manner possible, but let's just see if this is an exception to the rule, shall we? The city's complaint appears to be an unprecedented effort to seek penalties and resources expended in connection with allegedly false statements made to the police, where the related criminal case concerning the statements was dismissed nulla pros on all counts. First of all, a little course in Latin. What does nulla pros mean? Abandon or dismiss a suit by issuing a nolle prosequi. Seems like a highly circular definition, but let's just go see what nolle prosequi means now. Nolle prosequi, a formal notice of abandonment by a plaintiff or prosecutor of all or part of a suit or action. So what are Smollett's attorneys arguing here? It's actually kind of interesting. They are arguing that the city of Chicago is attempting to recover the costs of an allegedly false statement made by Jussie Smollett, the charges of which were all dropped against Jussie Smollett. So they're arguing sort of that the city is attempting to recover costs on the basis of an allegedly false statement, when the criminal charges brought against the accused on the basis of that allegedly false statement were dropped by the prosecuting attorneys. This perverse tactic is entirely at odds with the form, function, and prior use of the FSO and CRO, which by design allow the city to impose penalties and recover costs where a party has violated the law. And Smollett's attorneys cite case law where a city went after a defendant because the defendant allegedly made a false statement that he had been stabbed, but he pleaded guilty to those charges. And they're going to argue that because Jussie Smollett neither pleaded guilty nor were the charges pursued, that therefore that is a bar to the city attempting to recover the costs from that allegedly false statement. Because we cannot lose sight of the fact that all we have now in the legal reality that is the Jussie Smollett case, Jussie Smollett's statements are only allegedly false. They have not been proven in a court of law to have been, in fact, in law, false. So they are allegedly false. So it's an interesting argument being raised by Smollett's attorneys. The city will respond, but that's not the only argument that Smollett's attorneys are raising. Smollett's attorneys are also alleging that the statement of claim doesn't contain sufficient facts to justify the claim against Jussie Smollett, such that it should be dismissed at a preliminary stage. Apart from the city's improper attempt to prosecute charges that the state's attorney dismissed, the city fails to adequately plead claims against defendants under the FSO and CRO. Both claims fail to state sufficient factual allegations to support a reasonable inference that defendants' allegedly false statements caused the CPD 1,836 overtime hours and the city paying $130,000 in overtime pay. But Jussie Smollett's attorneys don't stop there. No, there's plenty more to throw at the wall, and let's get to it on page 4. This lack of specificity and failure to adequately allege causation warrants dismissal for failure to state a claim. In addition, the city's FSO claim is deficient because it is not pled with the requisite particularity required under Federal Rules of Civil Procedure 9b. Because we're not done throwing things at the wall yet. Sorry, that's too much opinion. Finally, the city's CRO claim should be dismissed because it is an improper pleading seeking double recovery for the same conduct and costs sought in the FSO claim. For these reasons, the complaint should be dismissed under Rule 12.6b. What are Smollett's attorneys arguing here? They are arguing that the city is attempting to recover costs under the CRO, the Cost Recovery Ordinance, as well as the FSO, the False Statement Ordinance. And in so doing, they are basically attempting to seek double recovery for the same costs on the basis of the same facts. That is to say that if the city recovers its costs both under the CRO and the FSO, it will basically get double indemnification for the same amounts under two separate headers. Now, these are just Smollett's arguments, and the city will respond to them, and as far as I'm concerned, quite succinctly, but they are very interesting arguments. But it is important to understand your adversary's argument in order to properly respond to it. So let's get into it. At page 5, Smollett's attorneys go over the false statements that Smollett is alleged to have made to the city, and it reads as follows. The complaint alleges 3 false statements that defendant made to the CPD in connection with the police report. Whoa. The complaint alleges 3 false statements, not 3 allegedly false statements. Did we just have a judicial admission that Jussie Smollett made 3 false statements? All right, I am humorously playing lawyer right now, but here we highlight the importance of qualifying the false statements as alleged, as opposed to referring to allegations of false statements. Whatever, it's just semantics, but if one were to want to play lawyer and nitpick, one would say, oh, you just alleged 3 false statements without qualifying those false statements as alleged. Okay. First, the city alleges that defendant told CPD officers, quote, he was a victim of a racist and homophobic attack, despite knowing that the purported attack was not for racist or homophobic motives. The second allegedly false statement was that defendant told the CPD officers that his attacker was white-skinned, despite knowing that the Osundara brothers are not white-skinned. Third, and finally, the city alleges that on February 14th, 2019, defendant made a false statement to CPD, quote, claiming that his only relationship with the Osundara brothers was as trainers and social acquaintances, claiming that they could not have been his attackers. Yet count 1 ambiguously expands the scope of the allegations, asserting that, quote, defendant knowingly made numerous false statements of material fact in violation of the FSO, including when he made a police report alleging that he was a victim of a racist and homophobic attack. As noted above, the complaint only pleads 3 false statements by defendant. To the extent that the city seeks to recover for other statements by the defendant, the complaint does not contain sufficient factual content to allow the court to reasonably infer that defendant is liable. Can we just appreciate what this argument is? This argument is that the city alleges 3 false statements but alludes to numerous other statements without going into detail about those numerous other statements. And because the city has alleged more than the 3 false statements already alleged in their proceedings without providing the detail, the statement of claim does not contain sufficient factual allegations to allow a court to reasonably infer that the defendant is liable. There's an expression in law, be careful what you ask for, because if Smollett's attorneys are asking the city to detail the numerous other false statements Smollett may have made, the city might do that. But one thing seems reasonably clear on its face. It's not because other false statements have not been sufficiently enumerated that the 3 that have been enumerated are insufficient to justify the claim against Smollett. The 3 false statements that are alleged by the city seem relatively specific and relatively sufficiently detailed, but I will get to the city's response, but that is the argument. Another argument raised by Smollett's attorneys in this motion to dismiss relate to the reasonable causal connection between the costs claimed by the city and the allegedly false statements made by Smollett. At page 6, Smollett's attorneys allege as follows. The city alleges that it, quote, is entitled to recovery of the costs of necessary services provided by the city in order to provide services in investigating and responding to defendants' violations of the MCC. Smollett's attorneys then go on to argue that the costs incurred by the city were not necessary and were not the direct or reasonable result of defendants' allegedly false statements. On that basis, the city alleges that the CPD expended significant resources over 2 weeks investigating defendants' allegedly false report. Over 24 CPD officers and detectives participated in the investigation of defendants' allegedly false statements, during which CPD allegedly logged 1,836 overtime hours, or 131 overtime hours each day for 2 weeks. The complaint, however, makes no allegations to establish what costs were necessary, much less any causal connection between defendants' statements and the CPD overtime hours, as discussed further below. Regardless of how you feel about Smollett, the argument is not totally weightless. I think it's weightless on a motion to dismiss, but not weightless on the merits. Let's take a hypothetical reductio ad absurdum. Someone falsely reports an immaterial hit and run to their vehicle because they were drunk driving and they banged into a post and whatever. They didn't want to get in trouble, so they report a false hit and run. Okay, what if in pursuit of this claim the city employs 100 police officers to work overtime to determine who was involved in this hit and run and incurs $1 million in overtime charges? Should the individual who admittedly filed a false police report be held to pay $1 million in damages because the city decided to go absolutely hog wild in their investigation? Probably not. Now, admittedly, this analogy fails because the crime reported by Jussie Smollett was sufficiently serious that by any account it would justify a serious investigation, even if it required overtime over a 2-week period. A racist and homophobic hate crime deserves a thorough investigation, but at the very least, conceptually, one can understand what Smollett's attorneys are arguing. If the city makes a decision to go overboard for whatever the reason and incur costs that are not directly related or necessary or reasonable in connection with the allegedly false statement, conceivably the amount being claimed could be reduced. Can it justify a motion to dismiss at a preliminary stage? Absolutely not in my mind, but I have been wrong in the past and I'll be wrong again in the future. But this cannot justify a motion to dismiss. It could be a good argument to reduce the amount claimed on the merits, but in my mind it cannot possibly justify a motion to dismiss at this stage of the proceedings. And the next argument raised by Smollett's attorneys is one of causation, and it sort of follows from the first, that there is not sufficient allegation of causation between Jussie Smollett's allegedly false statements and the costs incurred by the city in pursuing the investigation into the alleged attack. The city's complaint fails to plausibly allege proximate causation because the connection between the alleged false statement by defendant and the city's purported injury, overtime hours, is too attenuated. For the FSO claim, the city baldly asserts that it spent a significant amount of CPD overtime pay because of the alleged false statements by defendant without establishing how the statements caused the unforeseeable overtime expenditures. And Smollett's attorneys go into a detailed analysis of what they consider to be applicable case law, illustrating the principle that it can't be the, quote, but-for doctrine, that but for the fact that he made those statements, the city would not have done what it did. I think the argument is pretty weak that causation has not been adequately alleged. Again, there might be an argument as to whether or not the quantum claimed by the city should be reduced because not all of the costs incurred were absolutely necessary, whatever the applicable criteria is. But I think it would be difficult to justify a motion to dismiss at this stage of the pleadings, especially since the argument is basically predicated on the fact that, yeah, he may have made allegedly false statements, but the city didn't have to do what it did to respond to those allegedly false statements. If Smollett's attorneys want to create a precedent whereby the city is now going to be sort of deterred from vigorously pursuing an investigation into relatively serious allegations of crimes, they're going to be victimizing the world twice as a result of this. And at page 8, Smollett's attorneys make certain allegations which, as far as I'm concerned, hurt their argument more than it helps them. An intervening act between the defendant's conduct and the alleged injury may break the causal nexus if it is extraordinary under the circumstances, quote, not foreseeable in the normal course of events or independent of or far removed from defendant's conduct. And as far as I'm concerned, they are making the perfect argument for the fact that what the city did do was a perfectly foreseeable, totally reasonable, and to be expected response to Jussie Smollett's very serious allegations of having been the victim of a homophobic and racist hate crime. At page 9, Smollett's attorneys go on to argue as follows. Nothing from those facts allows for a reasonable inference to be drawn from those facts that the CPD overtime was a foreseeable, ordinary, and normal consequence of defendant's statements. Accordingly, the city's claim for overtime expenditures under the FSO fails for lack of causation. Now, here is a lawyer pro tip that I learned the hard way. When you use terms like reasonable inference, where you're basically saying that if the judge disagrees with you, the judge is not reasonable, it's not the best way to go about arguing something. What Smollett's attorneys are effectively doing is arguing that if a judge does believe that the inferences are there, that the judge is not being reasonable. They are basically calling any judge who disagrees with them unreasonable. But when you use words like no reasonable person would, you are basically calling anyone who disagrees with you unreasonable, and they are talking to a judge right now. End of lawyer pro tip. At pages 11 and following, Smollett's attorneys go on to argue that the city's statement of claim is not sufficiently particularized, doesn't contain the requisite particularity as required under the Federal Rules of Civil Procedure, Article 9b. Under the Federal Rules of Civil Procedure, for a claim alleging fraud, quote, a party must state with particularity the circumstances constituting fraud. And at page 12, Smollett's attorneys go on to argue as follows. The city fails to identify to whom the statements were made for each of the 3 false statements alleged in the complaint. And Smollett's attorneys go on to conclude that because the city's statement of claim does not contain the sufficient particularity, as in who the allegedly false statements were made to, that the claim must therefore be dismissed. Let's make some predictions right now. Drop a comment in the comment section below and let me know what you think is going to happen. My prediction, this motion to dismiss is not going to be granted. But full disclosure, I am batting 0% as far as predictions go on motions to dismiss, as anyone who's been following this channel for a while knows. And finally, Smollett's attorneys are arguing that the city's claim should be dismissed because it seeks double compensation under the CRO and the FSO, and let's break that down. Count 2 of the complaint, seeking recovery under the CRO, should also be dismissed because it improperly seeks double recovery for the relief sought in count 1. The city does not plead count 2 in the alternative. On the contrary, count 2 seeks to recover the cost of the necessary services provided by the city in investigating and responding to defendants' violations of the MCC. Accordingly, as pleaded, the city can only prevail on count 2 if it also prevails on count 1. And here is the crux of the very specious argument. Since count 2 cannot stand alone, any recovery for costs on that basis would be duplicative of the damages sought under count 1. Count 2 essentially seeks to recover these same compensatory costs that serve as the basis for the treble damages sought in count 1. Alright, so what Smollett's attorneys are arguing in a nutshell is as follows. The city is seeking recovery of costs under 2 headers, the first of which is the false statements ordinance, and the second of which is the cost recovery ordinance. If the city doesn't succeed on recovering the cost from the allegedly false statement under the FSO, it can't then also recover the costs under the CRO. And if it does recover the costs under the FSO, then it can't recover the costs under the CRO because that would be double compensation for the same damages. I hope that clarifies things, but now what is the response to all of these allegations? Well, let's see. City of Chicago's opposition to defendant's motion to dismiss summary of argument. As relates to Smollett's attorney's argument that the costs incurred were not necessary or reasonable, the City of Chicago responds as follows. This is not the rare case where proximate cause can be resolved on the pleadings. Under the FSO proximate cause standard, quote, a defendant is answerable for the neutral, ordinary, and reasonable consequences of his conduct. The complaint satisfies this standard by alleging that 1. Defendant falsely told CPD officers that he was the victim of a legitimate hate crime, and 2. CPD officers then incurred costs of investigating defendant's false report. Indeed, the entire purpose of reporting a crime is to enable the police to investigate. Maybe I am a simple man, but I appreciate simple reasoning. Smollett's attorneys are arguing that the investigation was neither necessary or the reasonable result of the allegedly false statements. And the city responds to that, you file a police report, the expectation is that we investigate. You expect us not to investigate once you file a police report? Sorry, I got excited. Defendant focuses his argument on the notion that the CPD overtime costs were not foreseeable. This argument fails. As an initial matter, the complaint seeks all damages, quote, in an amount to be proven at trial incurred by the city because of defendant's false statements, which includes but is not limited to overtime costs. Thus, even if the city's overtime costs were not foreseeable, the city's FSO claim would survive because the city also seeks costs incurred performing work during regular business hours. And that's the crux of the response. Even if the city hadn't incurred overtime charges, it would have incurred ordinary charges in pursuing that investigation. And so therefore, Jussie Smollett may have an argument to reduce or minimize the damages being sought by the city, but he doesn't have an argument to seek the dismissal of the claim at this preliminary stage. If the city is claiming more than it's entitled to, that is an argument on the merits, not an argument for a summary motion to dismiss under a Rule 12.6b, or 12b6, whatever, you know what I mean, Rule 12. And then further down, the city goes on to distinguish the case law being cited by Smollett's attorneys, and they argue as follows. This case is easily distinguished. First, the city need not show that it is a, quote, victim under a statute that makes restitution available for crime victims generally. Rather, the FSO expressly authorizes the city specifically to recover damages for false statements made to the city. Second, Derengoski was a post-conviction action, while this is a civil case at the pleading stage. Third, in Derengoski, the court emphasized that the state could not recover costs for monitoring protesters because those police duties were part of the state's normal operating costs. Hence, in contrast, CPD's investigation was not part of its normal operations and occurred only because defendant concocted a fake hate crime and reported it to police. That is a pretty decent response. And then in response to the argument raised by Smollett's attorneys that the statement of claim lacks sufficient particularity, be careful what you wish for, because the city responds as follows. A complaint alleging fraud must, quote, state with particularity the circumstances constituting fraud. To do so, plaintiffs must describe the who, what, when, where, and how of the fraud. The city's complaint does that. Who? Defendant made the misrepresentations. What? Defendant falsely stated that, quote, he was the victim of a racist and homophobic physical attack. When? Defendant made the misrepresentations on January 29th, 2019 and February 14th, 2019. Where? Defendant made the misrepresentation at defendant's apartment. How? Defendant made the misrepresentations orally. And I think this illustrates another point, that if there are any questions that the defendant has as relates to specific details, the time to get the answers to those questions is in examinations, depositions, discoveries. It's not on the basis of a motion to dismiss that a party can say, you didn't answer this particular detail, therefore your entire claim must be dismissed. And then further down, in response to the argument raised by Smollett's attorneys on the Rule 9b, the city responds as follows. Defendant's position incorrectly suggests that a complaint must include every detail of the fraud to satisfy Rule 9b. The Seventh Circuit has, quote, warned that in applying Rule 9b, quote, courts and litigants often erroneously take an overly rigid view of the formulation. And this court has made clear that a, quote, plaintiff satisfies Rule 9b by providing a general outline of the alleged fraud scheme sufficient to reasonably notify the defendants of their purported role. These are going to be questions of law that the judge is going to have to adjudicate on, and you can come to your own reasonable predictions as to what's going to happen. You've heard both arguments, now you can assess who has made the stronger argument. And finally, in response to Smollett's attorney's argument that the city is attempting to seek double recovery and therefore the claim should be dismissed, the city responds as follows. Accordingly, because the CRO authorizes relief that might not be available under the FSO, it is premature at the pleading stage to determine whether count 2 seeks an impermissible double recovery. And finally, to the point that I had mentioned earlier, even if a judgment could result in a double recovery, however, the case that defendant cites indicates that the appropriate relief is a reduction in the final judgment, not dismissal of the claims. And that almost goes without saying. If someone is seeking a double recovery, it doesn't mean that the claim itself is baseless. It means that they might be claiming more than they're entitled to, but that is a question for a determination on the merits, not an argument for a summary dismissal before one even gets to the merits to establish what amounts they are owed and whether or not they are claiming those amounts twice. And in conclusion, the court should deny defendant's motion. If, however, the court grants defendant's motion in whole or in part, the city respectfully requests that the court's order be without prejudice so that the city may cure any pleading flaws through an amended complaint. And that goes back to something we discussed in previous videos. When a lawsuit is dismissed with prejudice, it means that the plaintiff cannot refile with the required amendments. It means that the plaintiff cannot resue or sue again on a similar basis because their lawsuit has been dismissed with prejudice, with maximum prejudice. Without prejudice means that the plaintiff can amend or make the required changes to render their pleadings satisfactory to the required law or procedure, to include the requisite details by way of amendment or more detailed pleadings. So the city is saying dismiss the motion to dismiss, it should be denied, but if you are going to grant it, at the very least allow us to correct our pleadings, to add the requisite particularities to satisfy whatever deficiencies there may be in those pleadings. And now you understand the ins and outs of Jussie Smollett's motion to dismiss and the city of Chicago's response to it. It's amazing. If you like this video and you like my content, be sure to like, share, subscribe, hit the notification bell, leave a comment in the comment section, share my video with anyone who you think might appreciate it. If you want some merchandise, a Vlog Dog shirt, the link is going to be in the comment section below, and I'm designing a new shirt and I'm calling it Keep Calm and Vlog On. How awesome is that? Anyhow, at the very least, now you know your vlog. Peace out. Boom!